There has been a lot of buzz lately about this three-letter Uniform Civil Code. Assam CM has said that it would curb polygamy. Asaduddin Owaisi, on the other hand, has said that there is no need for a Uniform Civil Code. UP and Uttarakhand has seriously considered implementing it, and the central government has told Delhi High Court in January that the Uniform Civil Code will result in the integration of India. We have a common criminal code, but no Uniform Civil Code. A uniform civil code will mean a commonly enforceable set of laws governing marriage, divorce, adoption, inheritance, and other personal and familial matters. So, what exactly we have right now?
Britishers drew up the uniform criminal code for this country, but for saner reasons, they didn't want to disrupt the social fabric of the country. They let the civil procedure be. So, there's no uniform civil code. So each different community, each religious community, the Hindus, the Sikhs, the Christians, the Muslims, each of them have a different set of personal laws governing these issues: marriage, divorce, maintenance, adoption, inheritance and succession. Over the years now, Hindu law has been codified to some extent. In 1956, when Nehru was in charge, he wanted the reforms and he pushed some bills through. But even then, there is a lot of difference among Hindu personal laws in North India, in South India, East India. It's all different. But the other communities' personal laws are largely uncodified. So over the years, a demand has built up that we should frame a uniform civil code.
So, what are the laws under which these other communities are codified into?
So the Muslim community is largely governed by the Sharia law, and the Christians have their own biblical rules, which have these are basically customary rules which have continued over years and years. As a result, each community thinks it is inviolable. You cannot violate them. But Hindus have 4 laws which were codified the Hindu law, but otherwise courts have over the years narrowed this gap and somehow reconciled all these personal laws with the Constitution of India. As a result, the situation is not as stark as it is generally believed.
What are the reasons on which Uniform Civil Code is being opposed?
The first and foremost, Article 25 of the Constitution gives everybody, every community, every single religious community in this country the right to practice and profess their own faith. And every minority community therefore feels that their rights are being intruded when the state steps in and draws up a law which interferes with their personal laws. That is the main issue. And the largest minority community in the country, the Muslims, have always been very wary of it because they believe that Sharia law is important to their identity. The next problem would be, of course, of implementation. Even if we were to hypothetically draw up a uniform civil code, it would be very difficult to implement because everybody would seek exceptions. Sikhs would say this is inviolate for us, you leave this exception out. Hindus would say down south we can marry cousins and you leave this out of the scope of the personal law, and so on and so forth. So there will be so many exceptions that it would be like the Goan civil code.
There have always been objections to a uniform civil code. You must remember that at the time that the Constitution was framed, there was no Hindu code bill either. Ambedkar resigned from the cabinet after the Constitution was made, but before the Hindu code bill came into force. So codification of personal law was something which was at large when the Constitution was written. There was also a theory among the Muslims, especially led by the Jamaat-e-Ulema Hind, that the Constitution itself was a compact where minority rights were assured and that personal laws would be left to the minority to decide. So these questions were at large, and then once the Hindu Code Bill came in, then there was the Bombay High Court judgment also in Narswapa Mali, which sort of kept the position of personal law outside the ambit of law. This legal position having continued for a very long time, obviously there have been people who think that codification of personal law on a common basis throughout the country can only be codification based on the personal law of one religion alone. So there seems to be a feeling that this is a win-lose situation.
There are many differences within the Hindu Marriage Act or the Hindu code also, right?
Yes, Hindu personal laws differ from area to area. For example, the Hindus in the south, they have a matrilineal system, or in the northeast where the tribal culture also is very different. So these personal laws differ from area to area. Every state in fact has a different set of personal laws. Possibly realizing the impossibility of framing an all India uniform civil code, the central leadership has left states free to enact their own laws, because then they can give their exceptions according to their own state's constraints. For example, if a local custom allows a Hindu man to marry multiple times, then they will leave a scope within that law to do it.
Hindus, including the South Indian Hindus, lives in America, lives in Singapore, lives in Japan, lives in UK, all the Western countries they live, and they are very happy with the common civil code. And not only the foreign, all Hindus, Muslim, Parsi are very comfortable, very happy in the Goa with the common civil code.
So, what are the reasons given in favor of a uniform civil code?
The advantages are many. Legal researchers say the most important beneficiary community would be women. See, because Hindu codified law gives women more or less equal status as that of a man in terms of property rights, in terms of the grounds of divorce, in terms of maintenance. But Muslim personal law, as an example, or even Christian personal law, do not give this.
Even after 75 years of the independence, we are governed by personal laws. Personal laws and secularism cannot go together. Either we should govern by the personal laws, otherwise through the secular laws. Unfortunately, particularly our daughters don't have equal right. Minimum age of marriage for Hindu daughter is 18 years. Minimum age of marriage for Muslim daughter is just 9 years. Means she has not completed even his primary schooling. Likewise, if daughter is going through the divorce, Hindu daughter, she will get maintenance, alimony. Unfortunately, our Muslim daughter don't get. Like grounds of divorce are totally different for Hindu and Muslim. Procedure of divorce is totally different for Hindu Muslims. There is no maintenance alimony for Muslim daughters. This succession is totally different. Inheritance is totally different. Muslim daughters cannot adopt child. So this adoption is also totally different. Guardianship rule is also totally different. We are in 21st century, and we talk about the gender justice, gender equality, which is impossible without having a common civil code. You can say a uniform civil code, you can say a common civil code, but I say it Indian civil code.
How does it work outside India?
No, it is very easy for them because Europe is culturally homogeneous. There are majority Christians, and so they have had it much easy. They have framed uniform civil codes which apply to all citizens across the board. It's also the literacy levels are different, so acceptance is easy. Social change has come in religion, so people accept it easier. Even in Islamic countries, the law has been toned down, and now you cannot marry multiple times without permission of the wife. But these are homogeneous societies which find it much easier to frame these laws. In a heterogeneous country, it is very difficult.
So, Samanwaya, has there been any cases where court have stepped in and recommended any uniform civil code?
Yes, the Supreme Court has time and again said that you must have a uniform civil code to integrate the society and also keep conservative elements in every society at bay, especially in the Shah Banu case, which was very interesting. In the Shah Banu case, Shah Banu was divorced by the husband and she was denied maintenance. And as per the personal law, which says that you cannot give maintenance beyond 90 days. Now, she moved the courts, the civil courts in this country under section 125 of the CRPC. Now, the courts granted her a very measly sum of 400 rupees per month as maintenance. But her husband appealed against that decision. Now, while all this was happening, the Rajiv Gandhi government stepped in and brought in a law which said that we will not interfere with the Muslim personal law, and if Muslim personal law says that there is no maintenance beyond 90 days, there should be no maintenance beyond 90 days. And basically, he propped up the conservative elements in Islamic society. Now, thankfully for the court said no, section 125 CRPC will apply, and they gave her that that maintenance which she enjoyed, and that law that the Rajiv Gandhi government had brought in remained a dead letter, in the sense that no court uses it ever to deny any rights to a Muslim woman. So courts have not only recommended UCC, they have also worked over the years to increment, in an incremental manner, change personal law.
12 High Court says that please bring uniform civil code, common civil code. But it is not, it has not been implemented till date. It's because of the appeasement politics, because of the vote bank politics, because of there are so many dimensions. But my submission is this: why, if I have four daughters, one daughter marries with a Hindu, another go marry with the Muslim, another with the Christian, and another with the Parsi, why my daughter's right should be different after marriage? Why? They all are Indians. They all are Indian citizens. Why our constitution says Article 14 equality before law, equal protection of Article 15 says you cannot discriminate based on religion, race, caste, etc. Article 21 says you provide right to life, liberty, and right to dignity to everyone. And so far as the right to religion is concerned, like many people say that no, we have the right to religion under Article 25. Please remember, right to religion under Article 5 have three limitations: subject to public order, health, and morality. So any riti, any pratha, any custom which is against the public order is not protected under Article 25. Any custom, any riti, pratha which is against the health, that is also not protected under Article 25. Similarly, if any act, any custom is immoral, that is also not protected under Article 25.
Some say that Special Marriage Act of 1954 is also an attempt on making uniform civil code, but it hasn't picked up that much. It is only used in case people from two community, if they marry. So there are many loopholes associated with it. Can you please take us through those?
Yeah, the Special Marriage Act was actually intended to allow two people of different castes or religion to marry without converting to the other person's religion. Each retains their own religion. So it's a very good piece of legislation. It was intended to be the start of a uniform civil code. Unfortunately, there were some provisions which did not go down very well.
Are you going to say that every Indian, irrespective of community, shall be married only under the Special Marriage Act? There is a Special Marriage Act. Or are you going to say that the only way that a Christian, Muslim, or a Parsi can marry is to go under the Special Marriage Act? That also would not stand the test of law or reason. So yes, there is the Special Marriage Act for those who voluntarily resort to it. But to make it compulsory or the only mode of marriage for one particular section of the community or the other may not work.
Where exactly, in terms of legislation and in terms of legal aspect, is Uniform Civil Code standing right now?
See, Uniform Civil Code covers those subjects which are on the concurrent list. So as a result, the central government should have been the one who should ideally frame a uniform civil code as a model, and the state should tweak it according to the local requirements. But here the reverse is happening. The states are declaring the intention to frame their own uniform civil codes, and what happens if they are all in conflict with each other? That will also be a huge possibility.
You already have at the national level, for a majority, that is for the Hindus at least, the Hindu Succession Act, the Hindu Marriage Act. Now, can you have all Hindus within the state of Uttarakhand or Uttar Pradesh or any other state which threatens its own version of the Common Civil Code? Will Hindus be governed by that? then what happens? Can you have marriages which will work all over India, but it will not work in one particular state or the other? So there are many questions. And secondly, as you know, plain constitution. If a state law derogates from the central law, where unless the president gives assent to the state law, it will not prevail within the state. So are you going to first enact a law which is contrary or in addition to, but slightly more supplemental to the state, to the central law, and then will you get presidential assent? It is simply calling for unnecessary confusion. If you want to do something, do it at the central level. This state law business is mere kite flying.
Has there been any draft uniform civil code that people can go through?
See, there are over 15 directive principles of state policy, but only 3 have been frequently invoked to give Gandhian idealism shape, like preventing cow slaughter and prohibition. Now, these are very popular for some reason. And the next is the Uniform Civil Code.
Those who raise a demand for a common civil code also seem to be saying that the law that applies to the majority should equally apply to the minority. So therefore, this phrase common civil code has become fraught with many expressions of triumphalism or majoritarianism, as well as fears of minoritarianism. I would personally think that if somebody were to come up with a religion neutral draft which incorporates the best from all and puts it out into the public domain, then a healthier discussion could ensue. That is not happening. Nobody has come out with a draft. Now, it's not as if even in the among Hindus there is one common civil law. Take the instance of marriage itself. There are many Hindu communities where marriage among first cousins, marriage between an uncle and a niece, routinely happen. But that is equally unthinkable among other sections of the Hindus. So, or the question of female succession, despite it being in the Hindu Succession Act, it was barely 2-3 years ago that the Supreme Court had to rule that daughters too were entitled to a full share in the property. So I think this question attempted with a cool mind when circumstances are not fraught, there is nothing which prevents a draft, a full draft coming out. Then the country might be able to take it forward, not in this current hodgepodge kind of situation.
It's a high time to all the personal laws, whether it's a Hindu law, Parsi law, Christian law, Muslim law, it should go. And we must have a gender neutral, religion neutral, common civil code. You can say Indian civil code. If we cannot have a common civil code, it can be 5 different, 5 gender neutral laws. Like we can make, just like the parliament introduced the age of marriage. We need 5 laws. We need one law to ensure age of marriage, common. Another law to ensure maintenance alimony. Another third law for succession inheritance. So rather than having a 5 laws, it's better to have one Indian civil code. You draft in a chapter wise, like Indian penal code. It would be much easier for courts. It would be much easier for common man. It will be much easier for advocates also.
12 different Europes in one subcontinent. Then it's very difficult to think of a draft. No one has ever drafted one. No one has even attempted one. All this talk has been going on for the last 70 years. We're yet to see a draft. Maybe this government will present us a draft.